Okay, I want to respect everyone's time who joined us bright and early at 8 a.m. On Tuesday, so we'll go ahead and get started. I will cover our typical administrative items. This is the November 12th meeting of the COTA Rewrite Subcommittee of the 1296 Task Force on the Rights of Coloradans with Disabilities. I'm Barrick Abramson with Confluence PSG, facilitating the conversation today, joined by my colleague, Carrie Steele. Few of the norms for those joining for the first time or listening as we are live streaming it over on YouTube. We do ask the members, if you're in a place where it's safe and comfortable to do so, to have your camera on, and all others to leave your camera off unless or until you are participating in public comment. If you would like to participate in public comment, I would ask you to drop a note in the chat to myself, Barrick Abramson, or my colleague, Carrie Steele. And on that note, that will be the one and only time that I do ask folks to use the chat. Otherwise, we ask everyone to avoid using the chat unless there is something pressing to share with everyone. That chat can be particularly distracting for those using a screen reader and also just distracting for anybody participating in the conversation. Final note, members, you're used to me saying this, but I want any guests to hear this. We do ask members to introduce yourself by full name the first time you speak on today's call, and anytime after that, at least by your first name, so folks are aware of who's speaking. I want to thank everybody for their flexibility in shifting time a little bit so we could make sure as many members as possible could participate today. We made some really good progress last week that I'll go over in just a minute, and I'm feeling pretty confident, although any one of you could throw me for a curve, that we can get through our remaining outstanding items, which have to do with some definitions, incorporation of some federal regulations, and a few other items. But we got through a lot of kind of the tougher issues last time. I want to just reground in process and in, frankly, the reason we're here. In terms of process, as you all know, but for anybody listening for the first time, we will be submitting a report from this subcommittee on the first business day, which happens to be December 2nd of the month of December, with your recommendations. That report will have a few things. It will have each of the ideas that you all have voted to be a recommendation to the executive committee. It will include the vote, and everyone on this subcommittee has the opportunity to include, either attributed to you or not, any reasons that you think are important for the executive committee and the public to understand about the reasons in support of or in opposition to any of the ideas. I'm happy to take your words verbatim if you'd like to send them to me. I'm also happy to jump on the phone and just get an understanding of if there are specific things you think are important for the executive committee to understand or consider as they deliberate on all of your recommendations. And again, that goes for if you supported or you opposed anything. So please do reach out to me, and know that I will probably be reaching out to you as well to make sure that everything is reflected. Yes, Mr. Montoya.
Thank you, Barrick. This is Andrew Montoya. Just to clarify, will our rationale for making the recommendations that we do be included in that report, separate and apart from any, dissenting opinions like you were just talking about?
Yes, I want to emphasize that rationale goes for both the majority or the minority of opinion. So whether you support or oppose, absolutely. And we're doing our best to capture it throughout. But if you have particular things that you want to make sure are included, happy to receive them by email or in a phone conversation. And again, to remind folks on the structure of the report, so it will have the recommendation, it will have the vote, including that rationale for opposing or for supporting. We will also include what is the problem we're trying to solve by making the recommendation, what is the end state we are seeking to create, and if this is an issue where you believe and recommend that there is a process to get there or a time horizon to get there, then we will include what you have said are the minimum next steps. I think in most of the ideas you all are putting forward, it's a little more black and white than what some of the other committees, but that is an option. And we're doing all of this because the executive committee will then take all of the ideas of all of the subcommittees, look at the legislation that created this task force, which we'll ground ourselves in just a minute, and they will then take their votes after deliberating and hearing some more public input on what are the recommendations. So we want them to be very clear on what your rationale is and what you see as the end state they're trying to create, or we are all trying to create. On that legislation, I do want to ground us back in that. I think it's very easy for us to get caught up in the technical nuance of what wording should we use, what is the cost of doing something, what is the cost of not doing something. I want to remind everybody about the values behind what we're doing here. This task force was formed after a number of pieces of legislation to address different civil rights and different rights of Coloradans with disabilities was withdrawn in lieu of creating this task force. And this task force, across all of its 4 subcommittees, has been charged with identifying the barriers for different aspects of life here in Colorado, whether that's participating in government and employment in government, whether that's enjoying the outdoors and recreation, access to housing, or in the case of this subcommittee, different forms of civil rights that are protected by the Colorado Anti-Discrimination Act and other laws. So this is really about addressing what is the lived experience of individuals with disabilities. Yes, you are all intended to consider all of the implications of any policy change, but I would ask everyone to think back to the stories we've heard of lived experiences for individuals with disabilities. Whether that's someone seeking housing, whether that's someone trying to get out to a ski resort, or whether that's someone who, because they were denied access, wasn't able to enjoy, whether that's a high school graduation or employment or anything like that. As I said, it can be really easy to get really technical and wonky on all of this. And I just want us to think creatively and boldly about how we can find that common ground among so many stakeholders that is about expanding access and the rights of individuals here in Colorado. With that, I'm going to lead us back to where we were, I guess it was about 2 weeks ago. And just to remind everyone, we had the opportunity to hear and discuss a little bit the public input we heard through the stakeholder input. We were focused on emotional distress and the caps and damages there. As you all recall, and I'm just going to do a very quick recitation here, we voted up or down each of the ideas that you had shared. When it came to amending revised statutes to remove the requirement for exhausting administrative remedies, you heard the stakeholder input in favor and opposed, and this subcommittee voted in favor of making that a recommendation to remove that requirement. When it came to adjusting the timeline for filing claims, again, we discussed the stakeholder input, all of your rationale for supporting or opposing, and you all voted in favor of standardizing that timeline so that it was consistent across all aspects of claims. We talked about allowing an individual to pursue emotional distress damages by revising Colorado revised statutes. And again, you all voted in favor of making that a recommendation. You did so with further recommendations that there be no caps on the damages that someone could seek, and that there be the ability to seek additional punitive damages. That all brings us to today, where we're going to talk about some of the public accommodations, and that's where we get into some of integrating federal regulations and rules, as well as discussing some of the definitions that we were working on almost a year ago when we all started this work last November and December, and decided to hold off putting forward recommendations to that legislative session until we had done all of our work. So we're going to go through the same process today. I want to give a little bit of time if anybody wants to reflect on our conversation 2 weeks ago, to reflect on the stakeholder input we have received, and then we're going to go through each of these one by one with the opportunity for every member to share their thoughts in favor or in opposition, or to suggest revisions based on the stakeholder input that we have received. I do want to preview, whereas last time we were able to discuss a lot more specific input from different stakeholders on the items we were discussing, this time the survey response related to these specific items is much more limited. And I will share it this way, and then I will invite all of you, having read the letters, read the survey responses, to first share your high-level takes as we did 2 weeks ago. It essentially, for me, what I took away was there were people who simply said, yes, change it this way. There were those who said this is complicated or could lead to additional costs of doing business in Colorado, and that cost would be too high to make this change. We did have some, and I want to talk about what we got from stakeholders prior to the election last week, and some conversations I've had since then. We had some, particularly as it relates to incorporating federal regulations into Colorado state law, making reference to the fact that the Supreme Court had ruled to make some changes, particularly as it related to the Cummings decision. And those some people said it was right for Colorado to act as a state and incorporate things as they see fit. Others weighed in saying that the Supreme Court had ruled and that Colorado should acknowledge that and not attempt to make changes here locally. I will say that since the election last week, I have had several conversations with some of the stakeholders who submitted, who again made the same cases. Some said that in light of last week's election, it is more likely that Congress and the Supreme Court may limit rights and that therefore Colorado should take action to protect rights. There were others making exactly the opposite argument, that with the country having spoken overwhelmingly through a popular and electoral college vote, that Colorado should acknowledge that change in perceptions and look to the federal move there. None of that is obviously binding on any of you, and I am not making the case for any of those. I'm simply sharing what we have heard. So with that, what I want to do is before we start going into any individual item that we'll be voting on today, ask if anybody wants to reflect on the overall input that you have read or seen or listened to throughout the stakeholder input process.
Barrick, Tom Wheaton
Yeah,
here.
Tom, please.
So Tom Wheaton, um, uh, just comment on your last comment. Since we're dealing with CATA and the first acronym is Colorado, I think we definitely need to not be concerned ourselves with what's happening nationally or federally, but stick to this because I think that was our initial charge is to really focus on the state of Colorado and how that could be a shining example for other states to go likewise. So that's just my initial reaction to that comment. And then did you also want us to comment on the governor's administration comments, or are we dealing with that later today? I read what Carrie had sent.
No, you're welcome to. We will go through it, each individual item, and if there's
Okay.
things that anybody has weighed in, but if you want to provide just reaction to overall stakeholders or any of the administration or agency feedback, you're welcome to.
Yeah, at this time I won't. I'll let our communication happen a little more organically as a group.
Okay.
Thanks.
And I will just say, and again, this is not me offering my opinion, just reflecting back what I've heard from you. To Tom's last comment about this being the CADA, the Colorado ADA, I just want to, acknowledge that I heard from so many of you and from others that we should be looking at the federal ADA as the floor and not the ceiling, and that Colorado should be looking a little more ambitiously at what we believe rights are here in Colorado. Anybody else want to reflect either on the stakeholder input to date or where either our state elections or federal elections come into play, if at all? Okay, well, you're welcome to comment as we go forward. Otherwise, I'm going to move us right into our discussion. And I'll read the item, and people have the opportunity to offer thoughts. If your thinking has evolved, or if you want to offer thoughts in support of or areas of concern that should lead to opposition. And then once everyone has weighed in, we will go to votes on each of these if we're ready to. And I just want to remind folks, you're free to express support, to express reasons for opposition, or to express reasons that you think, based on the input we've received or the other votes we've taken, that we may want to revise anything. The first idea is to incorporate the 2010 Department of Justice ADA standards and universal design and the Department of Transportation ADA regulations into Colorado law by direct incorporation. With the note that to date, what we have done is incorporated by reference. And in light of the Cummings decision, the Chevron deference decision, and others, all of you had conversations about incorporating directly into law. When we get into the detail of how that's done, And I invite comments on this now, and we can capture them in the report. If you choose to make this recommendation, we will need to figure out when it comes to incorporating directly, is it as it exists today? Is it any ongoing evergreen process to incorporate? Or how do you want to approach that? But so the first one is to incorporate those DOJ ADA standards for universal design and the DOT regulations directly into law by incorporation, not by reference. The comments we received, other than those by agencies, were simply, yes, I don't understand this, and we would have concerns about anything that adds cost. Would anybody like to offer thoughts on supporting or having concern? Andrew, please.
Thank you, Eric. This is Andrew. So yeah, I'm fully in support of this recommendation. To begin with, the standards, the DOJ and DOT standards, are what exist under federal law. So although it may sound like a broad array of standards, it really is just the ADA kind of universal design standards. Um, things like doorways have to be 36 inches, pathways have to be 36 inches, reach ranges, some pretty basic stuff, but things that have the benefit of the expertise of the Access Board, which has promulgated these regulations and, been working on this for decades now. So I believe incorporating those standards into Colorado law, verbatim as they currently exist would be the best option. Kind of a forward-looking thing, like you're talking about, whether we incorporate the current standards or allow for further revisions. Those federal standards don't change very often at all. In fact, prior to the 2010 standards for accessible design, the last standards were 1991. So, we will have plenty of headway, plenty of knowledge if the standards are going to change at the federal level, and we can look at changing Colorado to accommodate any changes. So I would encourage adopting the standards as they exist today. With respect to the election results and how that affects everything here, I'm just going to kind of tell you guys a story. During the prior Trump administration, we were in the midst of a lawsuit about a service animal, and the service animal regulations and law is pretty straightforward. Pretty, it hasn't changed much over the years. And in the midst of that litigation, there was a piece of guidance from the Department of Justice that was actually rescinded during that case. Although we were ultimately able to still settle that case, given the breadth of other regulatory interpretation and how clear the law was, having that literally yanked out from under us in the middle of a case was not helpful. Um, I'm fearful that a second Trump administration will do similar things. So I believe incorporating those standards directly into Colorado law rather than by reference is critical. Thank you.
Andrew, and I just do want to clarify, uh, as it stands right now, we will take a vote on the idea as written, which does not speak to when this should be reviewed in the event any of these regulations are updated. I think we could, if anybody wants to propose a revision, we could do that. I would also invite any of you, if you'd like to suggest that we vote as is, that you could offer language, if you'd like it included in the report from the subcommittee, that speaks to the need for Colorado to periodically review or to respond to any future revisions in those regulations, noting, as Andrew called out, the infrequency of those regulatory changes. Ian, please.
Thanks, Barrick. Ian Kalmanowitz. I want to echo everything that's been said so far by Andrew and by Tom, both with respect to the election. And I'm glad that there are people out there that are thinking about that, but that really doesn't go to the charge that was given to this committee. And with respect to Andrew's comments, I share his sentiments about the incorporation. And I just want to add that this shouldn't be a controversial issue from my perspective, because we're not creating anything new here. We're taking a snapshot of what exists at a moment in time, making it part of Colorado law. This is, I would hope, is the least controversial of all of the things that we've done over the last year with respect to proposed changes to Colorado law to enhance the rights of Coloradans with disabilities. what we're doing is preventing the regulatory changes that Andrew was just talking about that happen from administration to administration. That was a symptom of that Chevron deference, or a bug in the system, as it were. And we're gonna, we've seen that as administrations change, and over the course of my career, as administrations have changed, regulations and regulatory interpretations have changed, and we're going to put a stop to that by doing this. So I wholeheartedly support it, and again, just want to point out that it shouldn't be controversial.
Thank you, Ian. And I see Spencer has joined. Spencer, so we are on our first item of discussion, which is the incorporation of the 2010 DOJ ADA standards for universal design and incorporation of DOT regulations into Colorado law by incorporation rather than by reference. And we're just giving folks the opportunity to weigh in. I had shared with everybody, Spencer, that the feedback is fairly limited so far on these ideas. It's either I support, I oppose, or I don't understand, with also some more recent comments, either that in light of the election, we should definitely be moving forward to advance Colorado's revisions, and others saying in light of the election, we should give deference to the national decision and not be trying to change Colorado by incorporating Colorado. We had just heard from Andrew and Ian. Would anybody else like to weigh in on this first idea of incorporating the DOJ and DOT regulations directly in the law by incorporation as currently written? Lauren, please.
I'm in favor of this. However, reading the feedback from the building association particularly gave me pause, because Colorado is such an expensive place to live. We have a lack of housing in all parts of the state. And so their comments did give me pause. So I'm just hoping those comments of mine could be attached to my vote.
Absolutely. With that, if there's no further comments, I will take us to a vote. But did anybody want to offer additional thoughts in favor, in opposition, or in concern, or notes of consideration? Okay, then we will go to a roll call vote on this. Alana Barris is not with us today. Andrew Montoya.
I'm sorry, just to clarify, a yes vote is for advancing the recommendations?
Yes, sir, it is.
All right, yes, thank you.
Cindy Vaughn. Cindy, are you with us? If so, you're on mute right now. I will come back to Cindy in just a minute. Ian Komanowitz.
Yes.
Lauren Schwartz.
Yes, with reservations.
Yes, and your note is taken and will be included. Spencer Kondick.
Yes.
Thank you, Spencer. Tom Aker, are you with us?
Yes.
Sorry, I was not voting for you. I was just acknowledging you're here. I heard your vote. Yes, thank you. Tom Wheaton.
Yes.
Thank you. Cindy.
This Cindy, I'm so sorry. My whole Zoom just put on me. So, yeah, my vote is yes.
Thank you, Cindy. So we have a unanimous vote in support with a clear note of concern and reservation about the cost as it relates generally and specifically to housing. And I appreciate you naming that. We'll make sure that gets incorporated into the report. I will next go to our second idea, which is along the same lines, and that's to examine and consider incorporating into Colorado law DOJ Title I regulations. Comments are copy and paste identical because people were just responding the same. And I will note, you'll see on a few of these, someone said either I don't understand this, there needs to be more information, or when we get to definitions, the definitions were not in fact included on the one pager because each definition was about a page. And some folks didn't read those in their entirety. But in this case, same copy and paste comments on the last one, but I will open it up to everyone. Reasons to or not to incorporate DOJ Title I regs, and that's 28 CFR Part 37 that we're referencing here. I will also ask anyone if they want to clarify this idea, because the idea is to examine and consider incorporating. And I want to be clear if what you are putting forward is the recommendation to examine and consider, or if you're putting forward the idea to incorporate, to do it. So I'll open it to the floor for comments in favor and support, areas of concern, and anything to clarify this. Ian, please.
Derek, just a point of clarification. We're talking about the Department of Justice regulations for implementing I'm sorry, let me restart. We're talking about 28 CFR Part 37, which is the Department of Justice procedures for investigating complaints or charges of employment discrimination based on disability. Is that right?
That's correct. Yes. Yeah, Lord.
I think I need some clarification on what we're voting on.
Andrew or Ian, would either of you like to speak a little bit to what those regulations address? And again, going back to it, I can share a little bit about, Lauren, how we got to considering incorporating it. And it is because they are regulations. And under the Chevron case, we no longer have the deference requirement. But Ian or Andrew, do you want to speak a little bit to that process that is addressed by these regulations? Lauren?
All right, I think I'm on the same page now.
Okay.
I do, Barrick, I'm sorry, this is Ian. I want to be sure we're talking about the correct regulations. I had thought we had talked about proposing to codify the EEOC's regulations, which contain all the definitions. These regulations just deal with investigation of complaints of discrimination. And I don't recall us ever talking about that, changing or incorporating the Department of Justice's regulations with respect to investigations of complaints of discrimination. I was under the impression that we had been talking about taking the EEOC's regulations, which they're in 29 CFR, I want to say 1614 or 1620. I can't remember off the top of my head, but I can find it in a second. Where all the definitions with respect to disability, essential function, substantial limitation, all of those things are stored. These regulations deal more with processing and forwarding complaints, deferral of complaints, things of that nature. And I'm not sure this is what I think we're just talking about the wrong citation.
Okay, and I am very willing to adjust that and have the discussion and follow all of you where you'd like to go with that. Cindy, your hand is up.
Yeah, this is Cindy Vaughn. So I am in agreement with what we were just talking about because that's my recollection as well. So I would appreciate it if we could take a look at that.
And Ian, if I can work with you to get the correct CFR citation here, but we can adjust this to so it's the Title I regulations relating to the EEOC.
Yeah, that was my understanding. So Title I of the ADA covers employment discrimination.
Yeah.
And the EEOC's regulations are at 29 CFR Part 1630.
And I'm looking at my notes, and I think this was an incorrect citation because the discussion, all of my notes on this do relate to the EEOC.
Okay. So yeah, this is where all the definitions of various terms like physical impairment, mental impairment, major life activities, substantial limitation, all of these regulations contain these definitions. And that's what I recall us talking about. So And I'm happy I can drop that link into the chat if anybody wants to have it available to them to look at right now while we're talking.
Appreciate that. And the only thing I will say is because there was an error in the statute, the CFR listed, we can certainly go to a vote on this. We will just include that note in with your recommendations so that the exec committee is clear. I know when I'm looking at the ideas and previous things we had posted online, all of it was related to the EEOC. We did get this wrong when we went to stakeholder input. Based on the stakeholder input, I'm not sure that anybody was supporting or opposing understanding which we were or were not referring to. And again, as long as we include that disclosure, I'm comfortable taking a vote today and moving it forward or not, depending on how all you want to vote. But do I have anybody who wants to move forward the incorrectly cited 28 CFR Part 37 that does relate to employment?
I would actually vote against moving that forward for the simple reason that our Civil Rights Division already has its own regulations for how they're going to investigate charges. And I know that we've heard from the division director on multiple occasions, and I don't believe it's necessary. Frankly, I mean, based on my own experiences with the division investigating charges, I don't believe it's necessary for us to take the DOJ regulations and incorporate them. I don't know what kind of hassles that would create for the Civil Rights Division with respect to the non-employment claims that they have to investigate as well, because the incorrect citation only deals with employment, not with housing or public accommodation.
And what I will probably do, and Cindy, I'm going to call on you next, for the credibility and transparency of this subcommittee's work and the work with the public, we will take an up or down vote on the idea as incorrectly cited, and then we will take a vote on the corrected citation. Cindy Vaughn.
Yeah, this is Cindy. So I'm definitely in favor of not moving the incorrectly cited citation here forward. However, I just wanted to follow up and comment on an earlier discussion that this committee had, which was that while we did discuss incorporating definitions of disabilities, we did specifically discuss not including examples of, how would I say, remedies, and I guess that might be the incorrect terminology, but what I'm referring to is, for example, we talk about different types of disabilities, and then in the ADA it does sort of outline like what is effective communication, and it goes into specific examples of interpreters, service support providers, and so on. And we did decide not to give examples because we didn't want to limit Colorado.
I appreciate you raising that. And Carrie, I'll ask you to make sure that note is in our notes and that we include that in the report, that there were discussions and deliberations of that. And we specifically, as a committee, decided not to move that forward.
And that was early on, and I think it was December or January that we did that.
Okay, with that, and I'm going to apologize in advance for what is going to be a little bit complicated vote. We are first going to vote on the incorrectly cited idea of incorporating 28 CFR Part 37, which members have now expressed desire to not advance. But because we shared this with the public, I believe we have an obligation for transparency to address it and then to move on the correct one, as you all have articulated. So the vote is to advance the incorrectly cited CFRs that several members have spoken in opposition. But I'm going to ask if you would like to vote to advance it. Andrew Montoya.
No.
Cindy Vaughn.
No.
Ian.
No.
Lauren.
No.
Spencer.
No, and I also just want to point out that the incorrect recitation, to the extent we incorporated it, it would actually be in conflict with a lot of what we discussed during the last meeting with respect to the process for filing an administrative charge in Colorado. So I'm not sure you could justify both, but my vote is no. Thank you.
Thank you, Spencer. And we'll include that acknowledgement. Tom Aker,
No.
Tom Wheaton.
No.
Thank you all. We will now vote to incorporate into Colorado law the U.S. DOJ Title I regulations in 29 CFR 1630, which is the EEOC regulations that you all had discussed. So the vote to incorporate those EEOC regulations. Andrew.
Yes, for the EEOC regulations.
Cindy.
I'm sorry, can you repeat that? I
Yeah,
had a little.
with the correction that we are referring to the EEOC regulations in 29 CFR 1630 to incorporate directly into Colorado law.
Yes.
Thank you, Cindy. Ian.
Yes.
Lauren.
No.
Spencer.
Yes.
Tom Aker.
Yes.
Tom Wheaton.
Yes.
Thank you all. And by a vote of 6-1, that will advance. We will move forward to the next idea. This, and I think we've talked about this pretty extensively, but I'll invite discussion, speaks to the Chevron versus National Resources Defense Council, which was the precedent prior to the Loper-Bright Supreme Court ruling. And the idea you all put forward, recognizing the changes that decision brought forward, was to codify into law the judicial deference established by the Chevron case prior to Loper-Bright to direct judges to give deference to the regulations or rules adopted by a government agency to implement a law if those can be reasonably seen to be consistent with the law. I will first invite discussion if anybody wants to speak to either Chevron or Loper-Bright, or what would be the environment in Colorado if we direct judges to give that deference to government agency regulations if it can be seen as consistent with the law. Andrew.
Thank you, Barrick. This is Andrew. I just kind of want to clarify what it is we're talking about here. So obviously there are regulations such as the EEOC, the EPA, the DOJ that have expertise in these various areas. You know, Congress isn't sitting there determining how many parts per million of carbon can be emitted from a particular facility, let alone what a facility actually is. Under the law, that's left to the the EPA, for example. We've got these decades of experience from experts in regulations, and the Loper-Bright decision ultimately means that any individual judge sitting in a particular case can decide that he or she knows better than those experts. So because of that, I am fully in support of recodifying or re-sticking to Chevron, allowing those experts to come forth with their expertise and allow us all to rely on that, rather than having a patchwork of whatever judge you happen to draw in your particular case.
Barrick, you're on mute.
Thank you. Still a little early. Anybody else want to offer thoughts on background, thoughts on implications, thoughts in support, or thoughts of opposition or issues of concern with this? Spencer, please.
So I have maybe a question that maybe someone here can answer. In terms of how we would codify this into Colorado law, are we going to be identifying specific provisions or specific regulations that we would expect judges to give deference to, or is the idea more just we're going to have an instruction that tells judges to disregard the Chevron deference and defer to perhaps the most recent regulations that the Department of Justice or other administrative agencies have promulgated? I think that's important. One item that I think is worth considering and discussing is the current or the incoming administration it seems to be that there's a um sort of expectation that they are going to defer a lot of these decisions to the states. I'm not sure how that is going to be impacted by some of these administrative agencies and how they'll promulgate those regulations, but I think that is something just worth considering and thinking about. I don't know, Andrew, if you or Ian have any thoughts on that, but in terms of how we would incorporate this and how it's going to be written, I think that's something that we want to consider.
And I will just offer from a process standpoint, you all are free to do one of a few things. If you choose to advance this idea, you can advance it as is, and that's it, and leave it to the exec committee or the legislature. You can advance it with revisions to name which regulations or regulatory bodies you intend to include or exclude, or you can vote to advance it as is with a side note of implementation considerations relating to which should be examined. But all are on the table for you, all as a subcommittee. Andrew.
Thank you, Barrick. This is Andrew. To answer your question, Spencer, the way that I had originally kind of conceived this is essentially redoing Chevron deference. So I'm thinking kind of across the board, and part of that is so that we don't create patchworks of, well, do we defer to this agency and not that other agency? And I also see this working hand in hand with our incorporation of those standards and regulations into Colorado law. So even if those should change at a federal level, to the extent that we have those in Colorado and have regulatory guidance helping interpret the law, things like that, judges would then defer to that rather than decide, well, this person's wheelchair is only 32 inches, therefore they only need a doorway that's 33 inches, something like that. So yeah, that's the way that I had conceived it.
Would anybody else like to speak to background, legal implications, ideas in support, ideas in opposition, or concerns or considerations about the implementation that should be included? Okay, we will then go to a roll call vote, and we are voting on whether to codify into law the judicial deference established by Chevron versus National Resources Defense Council prior to the Loper Bright versus Raimondo case to direct judges to give deference to the regulations or rules adopted by a government agency to implement a law if those can be reasonably seen to be consistent with the law. I'll mix it up and go in reverse order on this one. Tom Wheaton.
Yes.
Tom Aker.
Yes.
Spencer Kotnick.
Yes.
Lauren Schwartz.
No.
Ian Kalmanowitz.
Yes.
Cindy Vaughn.
Yes.
Andrew Montoya.
Yes.
The idea will move forward as a recommendation. I invite anyone to share with me ideas that you would like or notes you'd like to include, either for the rationale in support or opposed. With that, I will move on to what will be the final item of this piece, and then we'll go to definitions. This item number 4, revised Colorado revised statutes that incorporate caps established for damages by the ADA in 1991 to remove all limits on damages for discrimination in cases of housing, employment, or access to a public entity or place of public accommodation. You shared this with the note that juries are typically not, or juries are not informed of caps during trials or deliberations. This specific idea received, again, the same exact response as the others. People saying people need to follow the law. Someone said, I don't understand this. I need more information. We had one association say they're concerned about anything that increases liability or the cost of doing business. And I think you can reasonably ascribe many of the comments received both in favor and in opposition about the ADA and the right to seek damages, as well as people concerned about the litigious business environment or the cost of doing business. With that, I'll open it up to the group for discussion, either on reflecting on the conversations that led to this ideal recommendation the legal implications, the business implications, reasons to support, oppose, or notes that you would want considered. Andrew.
Thank you, Barrick. This is Andrew. I just kind of want to reframe this a little bit and clarify that the damages caps only really apply to employment cases. Housing, public accommodation, and public entities cases do not have and never have had damages caps. Nevertheless, I do fully support removing those damages caps for employment and making sure that they don't exist for the other types of claims as well.
Thank you, Andrew. Other member comments? Ian.
Thanks, Barry. This is Ian. You all have heard me bang this drum over the last year, and I guess this might be the last time you get to hear me bang it. So one more time. These caps were put into place by Congress with respect to the ADA and other anti-discrimination and employment statutes in 1991 and have never changed. We're coming out of an unprecedented time of inflation where we're seeing that the price of everything has increased dramatically over the last couple of years. But in that same period of time, these damages caps remained artificially low. It does not take into account the reality of the harm that people suffer when they're subjected to this kind of discrimination. This discrimination happens at work, which is, different than some of the other areas of discrimination we've talked about with respect to public accommodation or housing. We've talked a lot about the example of somebody who's not able to go to high school graduation because of an accessibility issue. But here we're talking about people who may be losing their job because of an accessibility issue or because of an employer's fear, irrational fear of having a disabled individual in the workplace. The caps are tied to a number of employees that the business has rather than any other rational indicator of what an appropriate damages amount would be. And ultimately, this is really intended to provide a remedy for somebody who's been a victim of illegal discrimination through no fault of their own. And I would strongly encourage everyone to vote.
Thank you, Ian. And I will just note, picking up on one thing Ian said, as a reminder to this group, and we will include this in the report, we did have an entire meetings discussion about various means of ascribing levels of different caps. As Ian said, the current law, the ADA, looks at business size based on headcount or total employees. You all had discussions about looking at different models, everything from gross revenues to EBITDA to net income to size of the business measured different ways. As you'll recall, you all decided not to advance any new scale or table based on any other type of measure and landed on this as remove them and ensure that they don't exist for any type of claim. Any other discussion points in favor, in opposition, of concern, or consideration? Okay, we will go to a roll call vote to put forward or not the recommendation to revise Colorado revised statutes that incorporate the caps established by the ADA in 1991 to remove all limits on damages for discrimination in cases of housing, employment, or access to a public entity or place of public accommodation. Going to the roll call vote on this, Tom Wheaton.
Yes.
Tom Aker.
Yes.
Spencer Kotnick.
Yes.
Lauren Schwartz.
No.
Ian Kalmanowitz.
Yes.
Cindy Vaughn.
Yes.
Andrew Montoya.
Yes.
The idea will move forward as a recommendation. As with the others, I invite and encourage anyone to contact me by email, phone, text, however you would like, if you'd like to include notes of rationale for supporting, rationale for opposing, or notes of considerations about the implementation of this. With that wraps that piece. What we have remaining to do is our definitions. These, I will tell you, received only one response, and that was from a professional association who simply said that the full definitions were not included in the one-pagers and that therefore they were unable to respond to them. You could intuit anything that you'd like from the others, but I have nothing else that spoke directly to those. Would anybody, before we talk about what I believe are 3 definitions, would you like to offer any background or general thoughts on these? Andrew, please. And this does bring us back. I think these were some of the very first conversations we had as we headed into the holidays one short, long year ago. Andrew, your thoughts?
Thank you, Barrick. This is Andrew. With respect to the first definition, I just wanted to point out that that is, again, the direct incorporation of the federal definition of the ADA. And that comes directly from the ADA Amendments Act that actually redefined and expanded the scope of disability, the phrase disability, in response to a couple of Supreme Court cases that had narrowed the scope of disability. So the Congress specifically repudiated those cases and re-expanded the definition of disability into what we have set forth on that document. And that's simply what we're considering doing, is incorporating that definition again into Colorado law. So should something change at a federal level, Colorado would still be secure in that definition.
Thank you for that context, Andrew. Would anybody else like to offer general thoughts? And as Andrew said, we will first be voting on whether to incorporate the definition of disability directly into Colorado law. As Andrew highlighted, this does come directly from the ADA definition, and we are simply looking to incorporate that directly into Colorado law. Okay, seeing no comments at this time, and with the continued invitation to send me or call me with any thoughts you'd like incorporated, we'll go to a roll call vote. And Andrew, we'll go back to starting with you first. Mr. Montoya.
Again, this is for the definition of disability.
That's correct.
Great, thank you. Yes.
Cindy Vaughn.
Yes.
Ian Kalmanowitz.
Yes.
Lauren Schwartz.
Yes.
Spencer Kotnick.
Yes.
Tom Aker.
Yes.
Tom Wheaton.
Yes.
By unanimous vote, the recommendation to incorporate the definition of disability directly into Colorado law will move forward to the executive committee. Our next item is the definition of qualified individual. And the note we have here is the term qualified individual means an individual who satisfies the requisite skill, experience, education, and other job-related requirements of the employment position such individual holds or desires, and with or without reasonable accommodation, can perform the essential functions of the employment position that such individual holds or desires. And I will note that our next discussion will be the definition of essential functions, but this is the definition of qualified individual. Would anybody like to offer thoughts in support, areas of concern, or thoughts of opposition to this incorporation of the definition of a qualified individual? Andrew.
Just to clarify on this point again, this definition is solely for the employment section, as far as I recall our previous discussions. So this would not be in the public accommodation or public entity sections. It would solely be in the employment sections of CADA.
And if you all would like for us to do so, we can incorporate that directly into what we're voting on. That as to the employment section of Colorado Anti-Discrimination Act, the definition of qualified individual shall be. Other thoughts, reasons of support, reasons of opposition, areas of concern around implementation? Ian, please.
No, thanks, Barry. This is Ian. At the very end of last year and into the beginning of this year, I had prepared a proposal with some definitions of terms that are not found in CADA, but that are found in the ADA. And qualified individual with disability or individual with disability was one of those phrases. And in the proposal that I had put together, it had gone beyond the definition that is being proposed now to include some additional language with respect to an employee being considered, or applicant, sorry, an employee or applicant being considered qualified if any ability to perform an essential function of the job was for a temporary period, the essential function could be performed in the near future, or the inability to perform the essential function could be reasonably accommodated. And I don't know what happened along the way that did not get included in the definition. I don't know if this got discussed at a meeting I wasn't at, but I support the inclusion of the definition of qualified individual with disability, but I would propose adding the additional language that I put together in a proposal back in the end, like I said, the end of 2023, beginning of 2024.
Ian, you all have the authority and the room to revise these recommendations. This will be one case where I make an exception to my earlier rule. Would you be able to drop that direct language into the chat so that I can read it out and everybody can have access to it?
Oh, all right. This is too long. Let me delete.
If you'd like to email it to me, you're welcome to.
I could do that. That'd probably be faster. My apologies. On the way.
Thank you. And I will read that to everyone in just 1 minute. And I know that's less than ideal, so I'll give everybody as much time, and you're free to ask whatever questions are necessary to be comfortable having the vote. Okay. So the revised language or additional language that Ian is proposing we include would mean the definition is as follows. Excuse me, I'm just forwarding it. So Cindy, I want to make sure that you have access to it in whatever form you need. Let me read this. Qualified individual with a disability or individual with a disability. The term qualified individual or individual with a disability means an individual who satisfies the requisite skill, experience, education, and other job-related requirements of the employment position such individual holds or desires, and with or without reasonable accommodation, can perform the essential functions of the employment position that such individual holds or desires, except that an employee or applicant shall be considered qualified if A, any inability to perform an essential function is for a temporary period. B, the essential function could be performed in the near future. And C, the inability to perform the essential function can be reasonably accommodated. Let me know if there's anything of that you would like me to read back. Andrew.
Thank you, Barrick. This isn't a request to read back, but just to clarify, the definitions that Ian sent over again define the term qualified individual with a disability. And I recall we had some discussion, and Ian, you may not have been there at that meeting, about removing with a disability and just defining the term qualified individual, simply because we're already defining individual with a disability elsewhere. So no need to have, duplicated definitions there. Other than that clarification, though, of just defining qualified individual, I fully support the additions.
Thank you. So if we move forward with this, we would be speaking only the definition of qualified individual. And what we are doing is adding the exceptions, particularly that Ian has here, of any inability to perform an essential function is for a temporary period. The essential function could be performed in the near future, and the inability to perform the essential function can be reasonably accommodated. Tom Wheaton.
This is Tom Wheaton. So just so I'm clear, this is in addition to the language we were going to consider approving. There's been no strikeouts of the original language.
Ian and Andrew, I'll let you suggest that. As I'm understanding it, what we're doing is adding particularly the exceptions. Ian, is that correct?
That is correct, Barrett. The only change was to add those three exceptions.
Okay, thank you.
And that piece I will drop in the chat to everyone, creating an exception, or some might say breaking my own rules, but I will also read it out. That it is except that an employee or applicant shall be considered qualified if A, any inability to perform an essential function is for a temporary period, B, the essential function could be performed in the near future, and C, the inability to perform the essential function can be reasonably accommodated. Andrew.
Thank you, Barrick. This is Andrew. This question's actually for Ian. At the end of item B there, should the and be an or do we want to have it be all inclusive?
It's a great question. I took this language directly from the Pregnant Worker Fairness Act. And I copied it directly. So I would recommend leaving it with the and. But an or would be more protective of the rights of people with disabilities. So since that's our goal, I would actually recommend that we change the language I prepared and change the and there at the end of clause B to an or.
So, and I will next go to Cindy and then Spencer. As now proposed for revision, the definition would be as written in the idea shared of a qualified individual, except that an employee or applicant shall be considered qualified if A, any inability to perform an essential function is for a temporary period, the essential function could be performed in the near future, or the inability to perform the essential function can be reasonably accommodated. Ian and Andrew, I'm going to ask you to clarify, should there be an or after or A, or only after B?
If you have an or after B, that's sufficient.
Okay, thank you. Let me go to Cindy and then to Spencer.
Yeah, this is Cindy, and I guess this is a question that's a little in the weeds and probably for the lawyers. But when we have that term near future, is there case law that defines near future? To me, it's a little nebulous.
Barrick, I'll answer that. This is Ian. There's not any case law yet. Like I said, this language came out of the Pregnant Worker Fairness Act, and where it was dealing with accommodations of pregnancy. Pregnancy generally lasts for a defined term. Yeah. And so I do believe near future is certainly something that would be up for potential debate. But I would add that presently, for example, under the ADA, a disabling condition that would last for less than 6 months is viewed as something that is temporary and may not necessarily meet the definition of a disability. So that would certainly provide some guidance. the idea behind this really is that if somebody is in a position where for a temporary period they're unable to perform the essential function of the job, let's just say, for example, a knee surgery that prevents you from climbing stairs, but your job requires you to climb stairs, you don't have the risk of losing your job permanently if you could temporarily be accommodated with other work.
Yes, Cindy, thank you.
Thank you, Ian and Cindy. Spencer, you had comments on this.
Yeah, I mean, I think I just raised my hand when we were talking about the and or issue. I think this absolutely needs to be an or type language. To me, the section C is somewhat subsumed within qualified individual. But I think A, B, and C are specific, like these are specific examples where an individual must be considered qualified. And I think if we have an and there, for each of those, that's going to get very confusing and very restrictive in terms of which individuals would be considered qualified under the statute. So I'm all in favor of the exceptions with the or language.
Okay, then again, I'm going to read this out because it is new language, but we would be going forward with the idea as shared for the definition of a qualified individual, that the term qualified individual means an individual who satisfies the requisite skill, experience, education, and other job-related requirements of the employment position such individual holds or desires, and with or without reasonable accommodation can perform the essential functions of the employment position that such individual holds or desires. We add the exception that an employee or applicant shall be considered qualified if A, any inability to perform an essential function is for a temporary period, B, the essential function can be performed in the near future, or C, the inability to perform the essential function can be reasonably accommodated. With that, we will go to a roll call vote. Andrew Montoya.
Yes.
Cindy Vaughn.
Yes.
Ian Kalmanowitz.
Yes.
Lauren Schwartz.
May I abstain? Is that an option?
You have that option.
Thank you.
Spencer.
Yes.
Tom Aker.
Yes.
Tom Wheaton.
Yes.
That recommendation, as revised to include the exceptions of the three items that are defined with an or between them, not an and, will move forward as a recommendation with note of the discussion that we had today. We have one more definition to go through, and that is the definition of essential function. And while you all have read this, I know we have some guests online, so I'm going to take a brief drink of water and then read this whole thing to you because this one's a little longer. Idea number 3, definition of essential function.
Can I interrupt briefly? I hate to do this
Absolutely.
to you.
No, you're welcome to.
I admit that I'm doing this to maybe streamline things because, again, back at the end of last year, beginning of this year, when I had put together some proposed definitions, I had included some additional language with respect to essential function. Some of it made it into this definition, but some of it did not. And so I just sent you an email with some language that would, at the end of B, Roman numeral little VII, little 7, there would be a little Roman numeral 8 and then a sub C.
Yep.
And I would ask that that language also be included. It has to do with the ability to perform the work remotely and the employer's obligation to show that the functions are actually essential if there's a dispute about this.
And Ian, I will acknowledge I don't recall why this was or wasn't included. What I will do is read the idea as shared, and then I will note where that stops and where the new language Ian is proposing would then be included with it.
Thank you.
And I appreciate you streamlining us by getting that to me up front. So, definition of essential functions, as written and shared. The term essential function means the fundamental job duties of the employment position the individual with a disability holds or desires. The term essential functions does not include the marginal functions of the position or job duties that were not essential at the time they were imposed or sought to be imposed on the individual with a disability. A job function may be considered essential for any of several reasons, including, but not limited to, the following. 1, the function may be essential because the reason the position exists is to perform that function. 2, the function may be essential because of the limited number of employees available among whom the performance of that job function can be distributed. And or 3, the function may be highly specialized so that the incumbent in the position is hired for his or her expertise or ability to perform the particular function. B, evidence of whether a particular function is essential includes, but is not limited to, 1, the employer's judgment as to which functions are essential. 2, written job descriptions prepared before advertising or interviewing applicants for the job. 3, the amount of time spent on the job performing the function. 4, the consequences of not requiring the incumbent to perform the function. 5, the terms of collective bargaining agreement. 6, the work experience of past incumbents in the job, and or 7, the current work experience of incumbents in similar job. Revision proposed would strike the and or from after 6, put it after 7, add a number 8, whether the job has been or can be performed remotely. An additional item C, an employer who disputes that an individual with a disability can perform the essential functions of the employment position the individual with a disability holds or desires must put forth evidence establishing those functions are essential. So the revisions to what was shared and what we received feedback on are 1, adding that whether the job has been or can be performed remotely is one of the items as to evidence of whether a particular function is essential. It is an item of 8 that you have now shared. An additional provision to this definition that an employer who disputes that an individual with a disability can perform the essential function of the employment position that the individual with a disability holds or desires must put forth evidence establishing those functions are essential. With that, I will invite comments in support, in opposition, any comments on background, ideas that you'd like noted for consideration around implementation, and I invite you to speak either to the entire idea or to the revisions that have been proposed.
Cindy.
Yes, Cindy, please.
I just, because it's been a while, I think it was in December that this language was put forth and we discussed this as a committee. But I'm wondering if you could just remind us of why these additions were recommended, recommended these revisions.
Absolutely. Ian, your hand was already up, but I know you've been knee deep, neck deep in this ideation over the past year.
Sure. So the one, I mean, the proposal to include this definition was from the notion at the time that the CADA does not contain these definitions. These definitions come out of the existing ADA and its regulatory guidance, also from controlling precedential cases in the 10th Circuit Court of Appeals interpreting the ADA, the 10th Circuit being the federal appellate court that covers Colorado and states. So the big addition here that was changed from what was circulated to everybody was that new Roman numeral 8, which is whether the job has been or can be performed remotely. That really is a result of just experience. There's no basis in, like, that doesn't exist anywhere else in the law. That's new creation. But we routinely are seeing scenarios where we have clients with disabilities that make it so they are unable to work in the office environment for a period of time, but they could work remotely for whatever the condition may be. I've had clients with bowel issues that need to be readily able to use a restroom. I've had clients that have worked from home and brought their laptop into the restroom with them. There's plenty of other disabilities or disabling conditions that make it so that somebody can't work full time in an office environment but can perform the job remotely. During COVID, we really got to see, or I guess during the COVID lockdown, we really got to see that remote work was a viable alternative in these scenarios. And by adding this, we just wanted to, or I wanted to ensure that we wouldn't be in a situation where somebody with a disability who's able to perform the job for all reasons but for their ability to get to the office is denied that opportunity or denied the ability to continue in that job. So that's the Roman numeral 8 in sub B. Sub C is a codification of what the existing law in the 8th, 9th, and 10th Circuit Courts of Appeals is with respect to resolving disputes over whether there's an essential function. And the notion, again, being if we want to protect the rights of employees with disabilities, we take this law and we take it from a judicial decision and put it into the statute so we don't have to worry about a Cummings versus Premier Rehab kind of situation where a higher court says, no, you got it wrong. That's not what the law should be. And, now those protections are taken away from these individuals. And the employer is generally the one that's in the best position to be able to provide the evidence that the job function is essential, particularly in the case of applicants as opposed to existing employees. With existing employees, the employee can say, look, I've worked in this job for 10 years and I've never needed to lift 85 pounds. No one told me I needed to lift 85 pounds until I had to have back surgery, and now I can't lift more than 20 pounds. And the employer is trying to say that the job function is essential. And in fact, we don't even have anything in the office that weighs 85 pounds. But with an applicant, we don't have that data set. And so by putting it on the employer to provide that evidence, it just levels that playing field to ensure that the employer doesn't just get to, create a list of essential functions that could then disqualify people from either being accepted as an applicant or continuing in the job due to a disability.
Andrew.
Thank you, Barrick. This is Andrew. This question again is for Ian as well. When looking at that last item about the employer producing evidence of the essential functions, are we talking about a burden of production or a burden of proof? And if it is the former, is there any quantum or quality of evidence that we're looking for that we would like to define? And if I could ask you to maybe touch on what currently exists and what your proposal is, to the extent that there's any daylight there.
So the language here is, I understand it to be a burden of proof, that it would be the employer's burden to prove that by producing evidence that the job function is claimed to be essential is in fact essential, which is the case currently in the 10th Circuit. I can dig up the site. I have it in notes from when I prepared these. I don't have it right in front of me. But yeah, that would be the idea. If there is a dispute about whether the job function is in fact essential, it would shift the burden of proof of the function being essential to the employer.
Ian, can I ask, are you are you proposing putting language of what that threshold of evidence or proof is, or keeping it as drafted that you shared?
I would leave it as drafted, and the default would be preponderance,
Okay.
which is the default in all these cases. I mean, none of the other parts of the statute that we've been looking at specifically say that the employee has a burden of proving things by preponderance of the evidence. That's the accepted default, unless the legislature wants to impose a higher burden. Like, for example, in some instances or some statutes where an employer can rebut an inference of illegal retaliation by clear and convincing evidence, which is a higher evidentiary threshold than preponderance.
Understood. Thank you. Spencer.
Okay, so I do have one issue with the current drafting of the essential functions, and it has to do with section V, which is the terms of a collective bargaining agreement. So I understand that this was basically taken directly from the ADA, which is fine, but the problem here is that when the terms of a collective bargaining agreement must be interpreted to determine an essential function of a claim, what that's going to do is it's going to transfer any COTA claim, a state COTA claim, into a section 301 of the LMRA claim. So for those of you, this is sort of complicated, and it's a very nuanced issue of employment law, but I think it's very important. So section 301 of the LMRA is basically what governs all collective bargaining agreements. And if a claim arises under section 301 of the LMRA, it must be litigated under section 301 of the LMRA in federal court. That is not a huge issue if you are bringing an ADA claim, because jurisdiction would be proper in federal court because it would be original jurisdiction. But if the goal here is to create state law remedies that are equal to the floor or above the floor of what the ADA provides, then by having a provision that says the terms of the collective bargaining agreement in the statute is essentially going to require any case that involves the collective bargaining agreement to be pursued in federal court. So I am all in favor of bringing the amendments and the statute set forth sort of by Ian, and as is with the exception of section 5, because it's basically going to render this definition meaningless in state court. It would allow claimants to pursue claims under section 301 of the LMRA, but it would essentially render this case or these definitions meaningless in state court. So that's the one caveat that I would propose. I'm all in favor of it with the exception of section 5.
I believe we have a friendly amendment to strike B5. Ian, since this was yours originally, I will look to you, and then we'll open it to the members for discussion, since we're now looking at striking and adding.
Yeah, thank you, Barrick, and thank you, Spencer. That's a great catch. This listing came directly from the federal guidance, right? This came right out of the ADA and out of the EEOC's regulations, which aren't concerned with state law or claims being brought in state court, and there would be no LMRA preemption to deal with. And so it was a great catch, and I'm 100% on board with that amendment. You're muted there.
By show of hands, does anyone object to or have a concern with striking item B5, the terms of a collective bargaining agreement? Okay, I'm going to take this to a roll call vote, but I am going to again do a full read through. One, because it's long, and two, Andrew, go ahead.
Thank you, Barrick. I've got another potentially friendly amendment I'd like to suggest as well. Going back to the previous discussion about burden of proof versus production, I would suggest changing item C to just make it explicit that it's must sorry, I'm looking at the definition. The employment position the individual with the disability holds or desires um, bears the burden of proof establishing that those functions are essential rather than must put forth evidence.
Ian, are you amenable to that?
Yeah, absolutely.
So Andrew, let me just make sure I capture your language exactly right. It would replace must put forth evidence and instead bears the burden of
Proof.
proving.
Yes.
Bears the burden of proof establishing those functions are essential. Or
Yes,
bears the
sir.
burden of proof that those functions are essential.
However that shakes out.
Yeah.
Yes, sir.
Okay, let me go through this with our two revisions, which I will call out as I read it. This is to recommend the adoption of the definition of essential functions in the Colorado Revised Statutes as follows. The term essential function means the fundamental job duties of the employment position the individual with a disability holds or desires. The term essential functions does not include the marginal functions of the position or job duties that were not essential at the time they were imposed or sought to be imposed on the individual with a disability. A job function may be considered essential for any of several reasons, including, but not limited to, the following. 1. The function may be essential because the reason the position exists is to perform the function. 2. The function may be essential because of the limited number of employees available among whom the performance of that job function can be distributed. And or 3, the function may be highly specialized so that the incumbent in the position is hired for his or her expertise or ability to perform the particular function. B. Evidence of whether a particular function is essential includes, but is not limited to, 1. The employer's judgment as to which functions are essential. 2. Written job descriptions prepared before advertising or interviewing applicants for the job. 3. The amount of time spent on the job performing the function. 5. The consequence of not requiring the incumbent to perform the function. Item 5 is stricken. The terms of a collective bargaining agreement will no longer appear in the idea and the recommendation. 6, which will now be 5, the work experience of past incumbents in the job. 7, now 6, the current work experience of incumbents in similar jobs. And or 7, which was 8, whether the job has been or can be performed remotely. C, an employer who disputes that an individual with a disability can perform the essential functions of the employment position the individual with a disability holds or desires bears the burden of proof that those functions are essential. We'll go to a roll call vote. And I would like to note that Tom Aker had to jump off the phone. He was in the document and send me a message saying that he was in support of this. Seeing that there are no further hands seeking discussion, we'll go to the roll call vote. Tom Wheaton.
Yes.
Spencer Kotnick.
Yes.
Ian.
Yes.
Cindy.
Yes.
Andrew.
Yes.
I'm sorry, Lauren, did I skip you?
That's okay. I'm going to abstain, Lauren Schwartz.
That's fine. Thank you. I'm just skimming through my spreadsheet, so I do apologize. With that, that concludes our discussion of the ideas and recommendations. That last one does go forward as a recommendation with the revisions to strike the requirement or the terms of collective bargaining agreement as being a piece, adding the item of whether the job has been or can be performed remotely, and setting the burden of proof on the employer that the functions are essential. That concludes all of our voting on our ideas and recommendations. We're a minute over, and I will apologize. What I will tell you is we are now working on the report. It's been being developed in parallel. That report will be fairly succinct and direct. It will include background of all of the conversations that we held. The appendices will include all minutes and agendas that were generated and any presentations made, so there's full transparency. It will discuss the outreach that was done. It will include all of the ideas that were created, including the votes on which of those advanced as recommendations, what the vote was, and any rationale any of you would like to include about reasons for supporting or opposing, as well as any notes about implementation that you would like included in that. We are going to be doing our level best to get these wrapped up the Friday before we head into the Thanksgiving week. I can tell you there is a possibility with 4 of these that some carry into Monday. I think this committee may be a little more straightforward. So I'm going to do everything possible to make sure that's available a week before Thanksgiving. We're not going to get into group editing and rewriting of this. What I will do is provide the version with commenting privileges for everybody to weigh in on any place that you think we got it wrong in what we're describing. I would ask for some consideration that we're all going to have different writing styles, and we probably don't have the time to nuance and wordsmith it. However, if we got anything wrong, or if you think it's important that we change the language, I will absolutely invite you to do that. Final note, as I've said throughout this, please reach out if there's things that you want to make sure are included in how we discuss the discussions that took place, the considerations and deliberations, or the reasons ideas were advanced or opposed. With that, my sincere thanks. It seems so short after a year together, but we will bring everybody back together to talk about where things are when they get to the exec committee. But if I don't speak with you, I hope anybody celebrating it has a great Thanksgiving here in a couple of weeks, that Mother Nature does not dump 2 feet of snow on us again, and that everybody gets a chance to relax. I'll follow up by email and just want to sincerely thank all of you, and we'll look forward to getting together again here in early December. Thank you all very much.